This next section is on bankruptcy. This is a debtor protection law. Historically, debtors had few rights. Compared to today, they have many, many more, including the right to file for bankruptcy. So what is bankruptcy? It's a legal proceeding that can help individuals and businesses who owe more debt than they can pay. And I will note that despite having the option of bankruptcy, the debtor does not have to be insolvent. They just have to owe money and they're behind on payments. Federal courts have exclusive jurisdiction over bankruptcy cases. This means that a bankruptcy case cannot be filed in state court. The U.S. Constitution prohibits the states from impairing the, quote, obligation of the contract, unquote. So the states cannot provide a means for discharging a debtor from a debt unless the debt has been paid in full. That's the only caveat there. So this is exclusively a federal law. So Constitution gave Congress the power to establish uniform laws with regards to bankruptcy, which it did. And it also amended several times, including the current law, which was adopted in 2005, which is called the Bankruptcy Abuse Prevention and Consumer Protection Act. For short, we call it the Bankruptcy Code, versus case law. This is case law is actually court's decisions, which there are some that interpret the Bankruptcy Code. So with that said, however, although bankruptcy law is federal, state laws on secured transactions, liens, judgments, and exceptions or exemptions, meaning that there are some personal property that's not going to be subject to bankruptcy, or like the house or a car. And we'll talk more about that. So in reality, state laws do play a role in federal bankruptcy proceedings. The primary purposes of the law of bankruptcy are two main ones: to give an honest debtor a fresh start in life by relieving the debtor of most of their debts, and to repay creditors in an orderly manner to the extent that the debtor has property available for the payment. Sounds simple enough, but that's really it: to give somebody a fresh start, get out from underneath a massive amount of debt, which could be something like a medical expense. They didn't have medical insurance. They had a major procedure, $200,000. That's not a crazy number for a big procedure, and they don't have a way of paying it. That is something that could be discharged in bankruptcy. So it gives people a fresh start, but also allows for the repayment of creditors in some fashion. The vast amount of bankruptcy cases, or I should say the majority of the cases, are filed under three main chapters of the Bankruptcy Code. Chapter 7, which we refer to as liquidation, Chapter 11, which is referred to as a reorganization, and Chapter 13, which is referred to as the adjustment of debts. There are others. I have them up here on the slides, but these are the three main ones, and these are the three main ones that the CPA exam tests on, with Chapter 7 being the primary one. But the others, as I note here, Chapter 9, Chapter 12, and Chapter 15 are available in those specific circumstances. Why do we have bankruptcy laws in our modern capitalistic society? Well, it's important to have. Let's talk about, and we'll talk about those laws, but let's talk about pre-reform. I said that the bankruptcy laws were reformed in 2005, and I'll give you some reasons why. Prior to that, about 500,000 million per year were filed. That was about roughly the average number. 2004, right before the new laws were to take effect, 1.4 million filings had occurred for one reason or another. But one of the major reasons why there was a push for reform were banks and creditors, i.e. credit card companies. They wanted to restore personal responsibility on debtors. It was very easy for folks to go in and file for bankruptcy and be discharged from their debt. And banks and creditors were facing significant losses. Bankruptcy losses to credit union lenders alone was $900 million a year. Other testimony at Senate hearings from creditors, $44 billion in losses. There were loopholes, there were incentives for filing, which would lead to abuse. Student loan debt was being discharged very regularly. Folks would go to school, take out loans, and then file for bankruptcy. The fact that some bankruptcy debtors were able to pay significant portions of those debts too, because they didn't have to show, you're going to learn about a means test, they didn't have to show that they have disposable income. They're just like, oh, I have debt, I'll go and discharge it. There was no real limitations. There wasn't a limitation on how many times you can file for bankruptcy. So it was really being abused. People were racking up a lot of debt and then saying, oh, I'm just going to go to bankruptcy court and get rid of it. So a lot of reform, and those are the laws we're going to talk about going forward. Bankruptcy types. We have two categories. We can really lump them in despite the many different chapters we have. We have a voluntary bankruptcy and we have involuntary bankruptcy. So a voluntary petition, is what it is. Somebody is voluntarily going to bankruptcy court and filing a petition. So that's the debtor. That is, and I use the term petition because that's the document that's used in court to start a bankruptcy proceeding. The filing of a voluntary petition is available in a Chapter 7, a Chapter 11, and a Chapter 13. There's no minimum number of creditors required to file for a voluntary petition. You can have one large creditor, that medical procedure that you didn't have insurance to cover for, just one creditor, or you can have multiple creditors. There is no limit. The debtor must state that he or she understands there's other types of relief rather than bankruptcy and other types of bankruptcy chapters that are available as well, not just one chapter wherever they're filing. They must be aware of all of the available areas of relief. They must provide a list of their assets and liabilities as well as their income. The failure to report or purposely leaving something off could be a crime. They have to list their secured and unsecured creditors, provide the addresses and the amounts owed, any property that they own, any expenses, liabilities. And they also have to provide a certificate that they have completed a debt counseling course. And they must do that within 6 months of filing. Bankruptcy estate or estate property. This is everything that the debtor has. All debtors' pre-petition assets. Let's say that defines or forms the bankruptcy estate, or the estate and property is another way to call it. So anything. They own a home, a car, a Van Gogh painting, a carat diamond ring, a classic car, a stamp collection, profits from property. Maybe they write books and they get, royalty fees, rental income, property that might be owed to the debtor by a third party. You lent your neighbor $3,000 2 years ago, they haven't paid you back. That's your estate property, you're owed that. And any interest in certain property to which the debtor becomes entitled within 180 days after filing, that becomes part of the estate. So a gift, insurance proceeds from something, inheritance would fall under that category as well. All of that is considered the bankruptcy estate, must be provided for on the petition. So if somebody goes out a week after filing and they buy a 70-inch flat screen TV or fancy Macintosh computer, generally those are not part of the estate property. But I will note that somebody who goes out right before they're going to file for bankruptcy and racks up a bunch of debt and then files, that stuff might not be considered for discharge. I'll note that, and I said this earlier, a debtor does not have to be insolvent or completely unable to pay. A husband and wife can file jointly on a single petition. The end goal here is they must demonstrate that the debtor owes some money and they owe it to somebody. So generally, as I said, property acquired after the filing of the petition is going to be exempt. So one of the things the court, so now we got our voluntary petition filed. The court is going to determine that this filing isn't abuse. Some of the grounds which would ultimately result in the dismissal of somebody's petition at this particular point of the case, failing to provide documents timely, conviction for a violent crime or drug trafficking offense, not allowed to file for bankruptcy, failure to pay domestic support obligations, child support, alimony, unreasonable delay in proceedings, you're intentionally delaying proceedings. The idea is that you're prejudicing the creditors, abusing the system. Somebody's acting in bad faith. That would result in a court dismissing a petition at this point. All of these grounds are also grounds for dismissal later on in the petition when we get to more of the proceedings and the trustee is involved and they're doing more of the investigation. So overall, at this point, these things could be looked at for a grounds for dismissal, but also later on in the proceedings. Once the court deems that the petition is in proper form and it's proper, there's no grounds for dismissal at this point, the court is going to issue an order for relief. This is where the court relieves the debtor of having to pay the debts listed in the petition. Basically, the court's granting assistance to the debtor. This does not mean discharge. This means that the bankruptcy can continue, the property's in the control of the court, and the debtor doesn't have to pay what they've listed in the petition. This step of issuing the order of relief is automatic if a voluntary petition is what's filed. If an involuntary petition was filed, the debtor can object, and if the debtor does object, the court will hold a hearing. If they don't object, the order of relief will automatically be provided. But let's talk about an involuntary petition. With an involuntary bankruptcy petition, it is the creditors that are doing the filing against a specific debtor. Here, the creditors are forcing the debtor into bankruptcy by filing their own petition. What they're trying to do is force the debtor to surrender assets so that proceeds can be used to be distributed among them. But what is needed to file under the Bankruptcy Code? One of two situations. The debtor has 12 or more creditors, 3 or more with unsecured debt totaling up to $16,750,000. That's the current number on that. This changes. I don't think it changes annually, but it does get updated fairly regularly. So that number will change. You have to refer to the Bankruptcy Code with regards to that number. But we're going to use the current one. That's what you need to join in on the petition. Or number two, if we have a debtor that has less than 12 creditors and 1 or more having unsecured debt of $16,750 to file. So for example, Poor R Us company is not paying its debts as they become due. Its creditors are A, B, and C. A is owed $18,000, B is owed $8,000, and C is owed $10,000. The question is, who can file an involuntary petition? Well, we're looking at example 2 here, fewer than 12 creditors, so that's number 2. And what we need is 1 or more having an unsecured claim above that $16,750,000 threshold. So A alone or B and C together could file for an involuntary petition. Certainly all 3 can join in together. A and B can join in together. A and C can join in together. But that's how that would work. How about Poor Inc. is unable to meet its current obligations as they are becoming due because of a severe business difficulty. It owes over $20,000 to a dozen different creditors. One of the unsecured creditors is Green, who is owed $17,000. And the question is, can Green alone file an involuntary petition? And the answer is no. You need This is where we have more. This is number 1 example. Here, where we have more than 12 creditors, he cannot go in alone on this. You need 3 or more. The automatic stay. In my opinion, I believe this is the most important concept that one should know about bankruptcy if you're not an attorney, especially an attorney who practices in the area of bankruptcy. But for an accountant, anybody who handles money for a business should be very well aware of this idea of an automatic stay. And I think this is why a lot of people file for bankruptcy. Upon proper filing of a bankruptcy petition, that date of filing, you don't have to get a determination of whether the petition is proper or not, i.e. the order of relief. What happens is a suspension of all judicial proceedings and litigation by creditors against the debtor. I don't think this is clear in the book how this works. Sometimes I think it gets confused with the order of relief. Attorneys advise people who come to them with a lot of debt, and they have a lot of debt collection and a lot of people trying to enforce their liens. The discussion that comes up is, well, if we file for bankruptcy, we can halt that. It halts those proceedings. Then it gives the debtor an opportunity to kind of readjust and make a plan. They don't necessarily have to go all the way through with a bankruptcy proceeding. But an automatic stay, really, if there's a debtor who is really being hunted down by creditors and being served with court papers, they're facing a foreclosure action on their home, this concept helps relieve that. So basically what this means is creditors cannot, once a bankruptcy petition has been filed, from that date of filing, creditors cannot commence actions against debtors or continue proceedings. They can't take action to repossess personal property. They can't enforce judgment. If they've already gotten a judgment from a court, they can't go and try and file it with a bank to take the money out of your bank account, so they can't enforce any judgments. Like I said, no foreclosure proceedings on homes. They can only now proceed through the bankruptcy court, and they would need to get permission to proceed any other way. They have to get it from the bankruptcy court. That's an automatic stay. Secured creditors tend to get a little bent out of shape when somebody files for bankruptcy and they have a asset or secured interest in one of the assets that the debtor has, a boat, a car, a home, right? We've talked about mortgages and we've talked about secured transactions. You know what I mean by that. And they've attached to it and they've filed for priority. They want the asset back. They have to go to the court and ask to be excluded from the automatic stay. They would have to show the court that they don't have adequate protection under the stay. An example of adequate, not enough protection or inadequate protection is a car. It loses its value, right? Over time, the longer it's hung up in a bankruptcy court for a court to decide what to do with it, it loses its value. And then they cannot, if they are allowed to acquire the car later on, they can't get enough money for it. So they can ask the court for the ability to proceed. And I'll talk more about that later on. Creditors who violate the stay, they are subject to court-imposed damages, attorney's fees, and sometimes even punitive damages. Soon after graduating from Applied Science University, Britta files a Chapter 7 bankruptcy petition. Before the court finds that Britta's petition is proper and enters an order of relief, she requests a transcript from the university. It refuses her request, claiming that she owes more than $6,000 in unpaid tuition. Can she still obtain her transcript despite the unpaid bill? And after our discussion about an automatic stay, yes, she can. She can obtain her transcript despite the unpaid bill. The university in this case is violating the automatic stay. The school is basically attempting to collect a debt. They're just saying, pay me $6,000 and you'll get your transcript, right? So this is a no-no. So Next, we're going to talk about the individual chapters, Chapter 7, Chapter 11, and Chapter 13. But before we do that, I want to make a note here regarding exceptions to this stay. There are no stays for actions in paternity, alimony, or child support. These things are considered outside the scope of bankruptcy. So if one of these cases is proceeding and somebody who is a party to that case files for a bankruptcy, these cases will not be affected by that.